Good afternoon, everyone. Good morning to those of us joining from the diaspora. I understand it's very early in the morning, so we are truly honored to be hosting you this afternoon. My name is 𝐊𝐞𝐴 I am an advocate of the High Court of Kenya, plus I'm a manager for real estate banking and finance at CM Advocates, the coastal region. I will be joined for this webinar by my colleague, Lydia Oludo, and we shall be looking at the title of our webinar is In Kenya, Foreigners are ineligible to acquire controlled and freehold land, but there are pathways. So we are here to clarify the law and explain the risks and present some actionable investment structures. Some housekeeping matters. The meeting is being recorded, so by you attending the meeting, you have indicated your consent. And then for questions that may arise during the presentation, we kindly request that you put them in the Q&A box, which we shall attend to at the end after the presentation. Thank you. For now, I'm going to invite my colleague Lydia to start us off with the presentation. Lydia, karibu.
Thank you, Sylvia. Good afternoon, everyone. Are you able to see me?
Lydia, we can see you.
Okay, thank you. Thank you so much. My name is Lydia, just as has been introduced by my colleague Sylvia. So I'll be taking you through the ineligibility of owning land in Kenya for foreigners. And I'll be taking you through understanding the land tenure, the restrictions, and then my colleague will pick it up from the safe investment structures. So I hope you'll enjoy the session. If you have any questions, you'll be free to ask at the end of the session. Thank you. So let me share my first slide. Okay, thank you. Now, basically, I'll be taking you through the legal framework governing land acquisition by foreigners. And I'll also discuss the ineligibility that foreigners face as they seek to invest in Kenya and also to acquire land. So first of all, we'll start with the cornerstone restriction, that is the 99-year rule. So basically, the principal legal framework that governs owning of land, or rather by foreigners, is stem from the Constitution of Kenya, specifically Article 65 of the Constitution of Kenya. So first of all, I would just like to state that in Kenya, a non-citizen may only hold land on a leasehold tenure only. So if that land exceeds 99 years, then post the 2010 Constitution, the foreigner, or rather the non-citizen, is not allowed to own that land unless you do like maybe a conversion, or maybe you explore other options, which my colleague will touch on later on in the presentation. So after getting the framework, or rather the legal framework that governs the landholding by non-citizen, When you look at that Article 65 of the Constitution, it's called an automatic conversion, meaning that if you have like any agreement, you have like any deed, or you have any document that attempts to grant a non-citizen an interest that is greater than 99 years, then it means that that property, or rather that land, will be automatically deemed to be a 99-year-old lease by operation of the law. So there's a recent decision, I think it's in April of this year. There's a case law that was decided in April this year that was touching about the self-executing the automatic conversion under section Article 65 of the Constitution. And I'll just read for you the citation, just in case you would like to note it down. So the case law, or rather the citation, is Paragon Electronics Limited versus the Chief Land Registrar and two others. And then there's Ngum and two others who are interested parties. It's a 2025 case decided in April. And in that case, the court held that that Article 65, Subarticle 2, which specifically talks about the automatic conversion, is a self-executing provision by dint of operation of the law. So when you have time, you can have a look at the case and you read more about the case. Yeah. So after talking about the case, I'll go to the current status of the existing titles. So you know that they're foreigners. Before the coming into force of the 2010 Constitution, there are foreigners who are holding freehold titles. And then there are also non-citizens or other foreigners who are holding leaseholds, but they exceed 99 years. When you look at some titles, you will find that they are 999 years. So both of those are deemed not to be held by foreigners post the 27 Constitution. So what happens if you're a foreigner, or if you have a client that is a foreigner and is holding a title which is a freehold and is also holding a title that exceeds 99-year-old lease? What do you do? So that will take us to our next slide, which we'll talk about the conversion of existing titles. And this one specifically talks about the conversion in regards to foreigners. For citizens, that is okay. For foreigners, if you do have an existing title that is a freehold or a title that exceeds 99 years, then the law allows you to have it converted and to a 99-year-old lease. So basically, conversion of the titles into a leasehold year not exceeding 99 years is governed by the Land Regulations 2017. And specifically, the part that talks about the conversion in relation to foreigners is Part 3 of the Regulations 2017. So the body that is tasked with this conversion is the National Land Commission. And National Land Commission in Kenya is the commission that manages public land, and it is the one also tasked with conversion of the titles to leasehold not exceeding 99 years. So I'll just briefly take you through the process, how that happens, how you can go about it to convert your land into a 99-year lease, or if you convert your leasehold title that exceeds 99 years to a 99-year lease. So the process, first of all, what will happen? The registrar at the locality where the land is situated will make a register of all those titles that are being held by non-citizens, and they are either freehold or leasehold that exceed 99 years. Then once that happens, then the National Land Commission will issue a public notification. And by this public notification, what they will do, they will have it gazetted. There's a prescribed form under the land regulations that the way the notice should appear. it will issue that notice to this non-citizen who is holding a freehold or a leasehold land exceeding 99 years. And this notice is done through publication in the Kenya Gazette and also in two newspapers of nationwide, at least in two newspapers of nationwide circulation. So the contents of that notice are usually three. So the first one, the commission will notify you that they intend to have your freehold or leasehold that exceeds 99 years converted into a 99-year lease. And then number two, they will let you know of the intention to have the affected land resurveyed, and for purposes of them issuing you the 99-year lease. And number three, they will let you know when that will happen, or rather when the resurvey will happen. So those are the contents of that notice that is being issued by the National Land Commission. Now, when that is over, then the commission, sorry, let me just go back to the previous slide. When that happens, then the commission will have that land resurveyed. Previously, of course, before title is issued, there is usually a survey of the land. So this land will have to be resurveyed again. And who does the resurvey? It is the body that is responsible for survey, which is the Survey of Kenya. That is the body that is responsible for survey in Kenya. So the Survey of Kenya will have it resurveyed, and then they will georeference, and they will also issue, or rather prepare the cadastral map and plan. So once that happens, then the owner, or rather the proprietor, the non-citizen proprietor, will surrender that title to the National Land Commission for conversion, or rather for issuance of a 99-year-old lease. So once the title is surrendered to the commission, then the commission will, and also, you see, once the commission received the original title from the non-citizen proprietor, and then number two, the commission has also received the cadastral map and the cadastral plan that was prepared by the Survey of Kenya. What they will do, they will forward all those documents to the cabinet secretary responsible for land. Yeah, so they'll forward those documents to the cabinet secretary responsible for land. And then, and why do they forward the documents to the cabinet secretary responsible for land? It's because he or she, or rather his office, is the one that will prepare the list. So once the CS, or rather the cabinet secretary, prepares the list, then it will forward that list together with the original title document to the chief land registrar. Chief land registrar means the chief land registrar, the locality, or rather where the land is situated. For example, we are in Mombasa, so assume the property was somewhere in Mombasa, and depending on where the property is situated, that is where the chief land registrar of that particular registry will receive the list together with the original title for issuance now of a new title with a 99-year lease. So I hope that is clear. So that entails basically the process of the conversion. And then something important to note about this conversion process is that the entire process is free of charge. Like, no government fees will be applicable. So for foreigners seeking to invest in Kenya, or rather if you're advising your client or someone you know who feels like, or rather they see the need, or rather as the law permits, they want to convert their title, and maybe they have a fear that they might incur additional costs in addition to what they had incurred before, then you can advise them that no government fees, processing fees will will be incurred, and the fees actually will be borne by the commission. It's the commission that bears any fees in relation to that conversion. And then number two, what you need to note about this conversion process is that what happens, you can ask yourself, what happens to transfers that happened post 2010? Let me be specific, post 27th August 2010, sorry. So what happens if you are a foreigner, or if you are a foreigner that sold land, or rather did a transfer of land post 2010, meaning post coming to force of the 2010 Constitution? What happens? And probably you are holding a title that is freehold, or a lease that exceeds 99 years. So what happens if indeed you did a transfer post that, then that transfer is deemed to, you have transferred a 99-year lease. So if ever you had bought land post 2010 and the transferor, or rather the seller, was a foreigner, and just know that regardless of the tenure, that lease, or rather that's the tenure that was transferred, is deemed to be 99 years. Yeah, so we'll proceed to the next slide. Now, we have a restriction on agricultural land. So this restriction also affects foreigners, because foreigners in Kenya, you cannot transfer an agricultural land. That is the general rule. You cannot transfer agricultural land. Why? Because for you to transfer an agricultural land, if I can just put it generally, it means whether you are a citizen or you are a non-citizen, it means you have to get a consent from the land control board in the locality where the land is situated. Now, narrowing down to the foreigner, if you're a foreigner, this is an automatic cancellation. You cannot transfer an agricultural land, or rather, you cannot like acquire. Sorry. You cannot acquire an agricultural land. So if at all you acquire an agricultural land, then it will be void. It will be void. Anyway, before even that land is transferred, there's usually that consent that needs to be issued by the land control board, consent, the locality where the land is situated. Though there is an exception though to that general rule. I'm yet to get hold of such an exception. So normally, the president has discretionary, let me call it a right, to grant a consent on exceptional circumstances. And I tend to think about these exceptional circumstances. It might be maybe this foreigner is a very large investor that maybe the government, after weighing all the options, deems will be beneficial to the public. Public means Kenya. So normally how that happens is that this right, or rather this presidential exemption, has to be published in the Kenya Gazette for it to be effective. So I'm yet to get one transaction that had a presidential exemption. Yeah. So generally, when you talk about restriction on agricultural land in regards to acquisition of land by foreigners, the governing law in Kenya is the Land Control Act. It's Chapter 302. And the Act prohibits transactions involving agricultural land that require the consent of the Land Control Board. So consent will not be granted to non-citizens or companies that are not wholly owned by citizens. So for the companies that are not wholly owned by citizens mean that these are companies that the shareholders have to be citizens of Kenya. So for instance, if you're a foreigner and maybe you were looking like for like a loophole in quotes to acquire land, and you're thinking of maybe incorporating a company, then all the shareholders, you can be a director, but you're not holding any shares. But all the shareholders have to be Kenyan citizens. And that also extends to the cooperative societies. Like all the officials of that cooperative society, they have to be Kenyan citizens for that land to, or rather that entity to acquire the agricultural land. So we can delve into what is not controlled land generally. We've talked about controlled land. Now, what is not controlled land? So controlled land is land that is not controlled is land that is not within municipalities, townships, or market areas, urban areas, unless that land has been expressly gazetted as agricultural. So you'll realize that there is land somewhere that is within a municipality. The general rule is that land falling within municipality or townships or market areas, or rather urban land, is not a controlled land. But you realize that there are times that they gazette specific areas. Those areas fall within a municipality, but then they gazette specific areas within municipalities considered as agricultural land. If that place, or rather that land is gazetted, regardless of the situation, then that land will be considered an agricultural land. So there are, however, certain dealings that do not require the consent of the Land Control Board. And then that is one land that is within a municipality, township, unless it is gazetted. And then number two, there's always transfer by transmission. So what is transfer by transmission? Transfer by transmission is a case whereby the succession process going on, and then land is transferred to the executor, or rather the personal representative, who might be also the beneficiaries of that. So when such happens, when that land is agricultural and the property is being transferred to either the executor or rather the personal representative, who might still be the beneficiaries, then that land do not require the consent of the Land Control Board. However, if that land will undergo a subdivision, for example, then you will have to get a consent. That is an exception. Generally, transfer by transmission, you don't get a consent from the Land Control Board. When you decide like, no, I want to subdivide it first, then now we transfer, then that one means you'll have to seek the consent of the Land Control Board. And then, because you see that subdivision will result into two separate titles. So it means that you'll have to get the consent of the Land Control Board consent. So going back, the reason why they do this, you see, the Land Control Act, it came into force to control unnecessary subdivision or fragmentation of the agricultural land. Kenya, this is because you see, like the agricultural land is considered like a source of like how do I put it, like a source of income or something of the sort. And that is the reason why the Land Control Act came into force, just to avoid unnecessary fragmentation of the agricultural land. That's why when there's transfer by transmission and you're doing a subdivision that will result into two separate titles, then you have to seek the consent of the Land Control Board. And the last one about land that is not considered a control land, then any land that is not which the government is a party will not be subjected to consent of to have consent of the Land Control Board. Any transaction, for example, it is the government acquiring the agricultural land, maybe for a public purpose or any other purpose, or maybe compulsory acquisition or something, and that land will not be considered control land, even if it is an agricultural land. And also there are these land that are acquired by way of settlement schemes. Like the way they settle squatters or the landless, like the government comes, purchases land somewhere, and then they want to resettle squatters. Then if that land is agricultural land, then that one will not be considered control for purposes of obtaining the Land Control Board consent to transfer. So let's go to the next slide. There's a growing argument, though, that this statutory restriction on foreigners owning agricultural land is unconstitutional, as the Constitution only limits foreigners to leasehold tenure, not the type of land. So while the law remains, this argument is important for maybe advanced client discussions. It's something you can think about it, maybe for future litigation. Yeah. So on to our next slide. Our next slide, rather what I'll present on will be the control land misconception. And being in Mombasa, rather being in coast, I'll try and be coastal specific a bit. So I hope by where I am right now, at least you figure out what control land is, what is not control land. So we have the historical issue that the Land Act had introduced the concept of control land. So let me just give you an overview of the legal framework governing the restriction on acquisition on land by foreigners in regards to the Land Act. Now, this Land Act, it operationalizes the Article 65 of the Constitution in regards to restriction of foreigners acquiring any land that is controlled. Now, what is controlled land anyway? It's land that you can't deal with it in any way unless you seek a consent from the specific authority or body. Now, why do you think that the government restrict certain areas that you can't acquire this place however you wish? You have to seek consent from the government. The argument by the government is that they may restrict or prohibit that foreign ownership or foreign acquisition of land by that foreigner in areas that they deem are strategic or sensitive for the national security. Yeah, so if they feel like if a foreigner acquiring a specific place might be a threat to a national security or how do I put it, to national security, then they will be like, okay, before you acquire that land, then you have to seek consent from us. And this consent may be denied or may be agreed to. Now, so in deciding whether to approve or not to approve an application for this application for those controlled land or places, then the Cabinet Secretary, of course, shall seek approval from different authorities. It will depend on where you are acquiring that land. If it is maybe near a national boundary of Kenya, if it is maybe adjacent to the Indian Ocean or something, then it will depend. So now, there was an amendment, a land law amendment in 2016. That introduced Section 12A in the Land Act. So what this amendment sought to bring was to restrict foreigners from owning or other acquiring land in specific regions or specific areas considered by the government as a threat to the national security or maybe strategic places. Now, that amendment introduced Section 12A in the Land Act. And what did it introduce? It redefined controlled land to mean that it is land located within 25 kilometers of Kenya's inland national boundary. And then number 2, it also defined it as land that is within the first and second rows from the high water mark of the Indian Ocean. And then number 3, it says that a controlled land can be any land that has been declared controlled by under any law or under any statute. Now, what happens in that amendment, they also tend to define an ineligible person, like the person who cannot own or acquire that land unless they seek consent from the government. They said, of course, someone who's not a citizen of Kenya. Number 2, the government of a country that is not Kenya, or maybe its political subdivisions. And then number 3, it was defined as an agency of such a foreign government that of a foreign government or its political subdivision. And then the last one was a body corporate, which I had talked about before, like a body corporate which is considered foreign. In short, none of the shareholders are citizens of Kenya. So what happened when this amendment came into place? The Malindi Law Society went to court to challenge the legality of all the 3 I've mentioned: land that is within 25 kilometers of the inland national boundaries, land that is within the first and second rows from the high water mark of the Indian Ocean. They did go to court to challenge that. Why did they go to court? What was the argument? Now, they said that the amendment that was introduced was discriminatory in the sense that it was restricting foreigners from owning land in those areas that the government considers strategic. Now, so there was also a case that was also filed by the Mombasa Law Society with the same facts. So those 2 cases were consolidated with the Malindi Law Society case that was filed before. So at the hearing of the petition, the 3-judge bench, the 3-judge bench listened to the parties, and the petitioners presented that the amendment sought by Section 47 was discriminatory insofar as the same sought to redefine the meaning of land in a person. And they argue that apart from the restriction on the period, that is the 99-year-old lease, then there was no other basis for restricting foreigners to acquire property in those places considered as strategic or rather controlled land. Now, the respondents, who are now the government, what was their argument? Let me just go back, maybe the citation about the case. Oh, it's there. Malindi Law Society versus 𝐒𝐲 and another. It was a case that was filed in 2016 but was decided in 2021. So you might want to have a look at it from the Kenya Law website. Kenya Law website. Now, that was the petitioner's case. And then what was the respondent case? Were the government, represented by the Attorney General. Now, the government argued that the reason why it was restricting such places from them having to seek consent before acquisition of such, it was because of the first reason I had stated about it needed to enhance the security measures by scrutinizing movements of people and goods in and out of the international boundaries. And they also stated that the rights and freedoms of people are not absolute. It is limited under Article 24 of the Constitution, and such. This is one of them that can be limited if the government considered it is for the public good. And then what was the holding by the court? Now, the court considered the definition of the control land as introduced by that Amendment Act, the Section 47(2), that introduced Section 12A of the Land Act. The court considered that and intended to define the control land as introduced by the Amendment Act, and found that it had far-reaching implications on the right to ownership of land as it was concerned with foreigners, and further found that as such, the state had not satisfied the court that there was enough justification to warrant them to have those places controlled. So that case was decided in 2021. You can have a look later on, and maybe you can have more insight into it. So far, that is the position as it stands, going by jurisprudence after that Malindi Law Society decision by the court. Yeah. So the current impact is that the restriction requiring the cabinet secretary approval for transaction in this area is no longer legally binding, and you can justify that by using the case that I've cited before. And the court clearly made it clear that the core restrictions remain the 99-year-old lease limit and the agricultural land prohibition. Yeah. I think I'm done with the first part of the presentation. I will just introduce my colleague, Sylvia, who will take you through the practical solutions and safe investment structures. And then in case you have any question from my presentation, you can just put it in the Q&A and be able to note them down. And after she presents, I'll be able to answer. Either of us will be able to answer depending on the question. And let me welcome my colleague, Sylvia. Welcome.
Thank you, Lydia. Thank you for taking us through the first part of the presentation. Allow me to just share my screen so that I'm able to take you through the second part of our session. I believe you can all see my screen. All right, thank you. I'll be taking you through the solutions which allow foreigners to safely acquire land which they are ordinarily restricted from holding in Kenya. So I'll just dive right into it. Then later I'll be considering the pros and cons of each. So the first one would be the change of use, which would entail an application by the landowner to change the use from agricultural to either residential or commercial. For those, a foreigner is not restricted from holding. Another option is a joint venture with a Kenyan citizen. The Kenyan citizen's purpose is to retain the title, the legal title to the land, which would thereby bypass the foreign ownership restriction. And then the foreign investor would come in to provide capital, equipment, markets, or expertise. Now, their contractual obligations will be set out in the formal JV agreement in terms of sharing profits and what other rights they may have in that relationship. The third is through investing through a public company. The Land Control Act does not expressly restrict dealing of shares in a public company holding agricultural land. Therefore, the foreign investor can acquire shares in a public company and indirectly then hold the agricultural land. The fourth solution would be to register or incorporate a limited liability partnership. This one is also not expressly restricted under the Land Control Act. Therefore, a foreign investor can form an LLP that holds the land and thus indirectly hold the interest. I'll go to my next slide. So the first thing for a foreigner, before you proceed to make any payments or before you proceed to acquire any property, it is critical for you to undertake due diligence. And due diligence does not just mean conducting a search at the lands registry. It involves other forms of checks, which is why then we would insist that when you are interested in acquiring any sort of property in Kenya, it is always advisable to engage a professional. Either you can engage a law firm, a lawyer, or a surveyor, but for best results, it is better to involve both those two professionals, a lawyer and a surveyor. So the first thing you would be determining for your due diligence check is a form of tenure of this land. So you need to be making sure that the interest to be acquired is not freehold. You need to check that. If it is freehold, my colleague Lydia has already discussed how to go about the conversion process of the freehold land to leasehold. Although this restriction is not essentially a big red flag because it's already deemed to be a leasehold from the promulgation of the Constitution in 2010. Then the other thing you'd need to be confirming is the use of the land. So you ought to check with the physical planning offices. I believe each county there is a physical planning office. So you need to confirm the use of the land and that it is not agricultural. Then thereafter, you also conduct a registry search. You check through the land records that are held, confirm if there's a presence of any encumbrance, whether there are any disputes, whether there's a caveat. You also need to ensure you comply with all necessary laws and obtain all approvals where applicable. I've already mentioned seeking professional advice, where you would be required to engage a lawyer and a surveyor. This is very essential to mitigate any risks that may come up in that transaction. You also need, as part of the due diligence, to ensure that any land rent, if at all, is paid and it's up to date, and the landowner, prior to transferring to you this property, has acquired a clearance certificate. And then we go to the next slide. I will deal with the matters of the ELC and the implication ahead. So I'll just dive into each of those 4 solutions I have discussed about. So what is a change of use? A change of use is an application to the county and national government to reclassify the land from the agricultural use to either residential or commercial or any other non-restricted use for a foreigner. In our experience and in our practice, we have found that this is the cleanest solution because once it is approved, then the restrictions under the Land Control Act no longer apply. The foreigner can then acquire the 99-year lease securely. And when we are now negotiating the terms of the agreement for sale, and we found in our due diligence exercise that the land is agricultural, then we would make it a condition precedent to the completion of this sale that a change of user must be done. Now, the nitty-gritties will basically depend on what the parties agree, but ideally, the onus of attending to the change of use is on the landowner, because they're the ones who need to be making sure they're transferring a clean title to you as the buyer and as the foreigner here. The only downside to this, but each transaction differs. The application can be complex, can be time-consuming. It also may be rejected by the county planning authorities, but it remains to be the cleanest and best solution. And the sale contract must have a strong long stop date and exit clause, which allows us some flexibility in the event that it takes a longer period of time than anticipated, which would allow now the buyer a full refund of the deposit if a change of use has not been obtained. Another way of dealing with it is to say that the sale agreement takes effect once the change of use has been approved. And in that way, you know that it's going to come to an end, whether it takes a long time or not. I'll go to the next solution, which is a joint venture. This one is basically contractual, and it doesn't affect the title at all. So it would involve a foreigner entering into a joint venture with a Kenyan partner who would contribute to the land, and the foreigner would now come in as an investor, providing capital or expertise in a shared project or a special purpose vehicle. The special purpose vehicle can be in the form of a company, can be in the form of a partnership. Now, this solution bypasses the Land Control Act entirely because there is no transfer of land. Now, I must mention, unless the parties decide to transfer this land into a special purpose vehicle, which then again, you'd have to look at the restrictions applicable under the Land Control Act. So you'd only be allowed to trade through, if the land is agricultural, you'd have to trade through the vehicles which have not been restricted under the Land Control Act. A private company, we've already seen, is restricted. We will deal with the public company and the LLP after this slide. So have that in mind when I'm talking about the special purpose vehicle. And then the legal implication of this joint venture is that the foreigner's investment security depends entirely on the agreement and not on the land title, because at no point will the land title be registered in the foreigner's name. So your contract will be operating as your primary asset and ownership of the land. So the big risk with this solution is that it's a partner risk. The Kenyan landowner retains the legal title. There is no way of preventing them from attempting to sell or charge the title to the property. You basically have very limited control on what happens. So to mitigate against these risks, the JV agreement must be meticulously drafted to cover any risks that we may foresee happening. And then you cannot secure your investment with a direct charge or mortgage, especially so if the land is agricultural, because you would require LCD consent. So security here would be better achieved by a charge over shares in the SPV or a pledge of the title deed. Solution number 3 is the public company. A public company is a corporate structuring solution. The Land Control Act's 100 citizenship ownership rule of properties applies to private companies. So a public is explicitly restricted in the same way. So what is the positives of setting up a public company? It is a statutory gap that would allow foreign shareholders to indirectly hold the interest in an entity that owns, or rather an interest in an entity fully owning agricultural land. Now, the legal implications with the coming into force of the Companies Act 2015, there is a lot of oversight and potentially the Capital Markets Authority oversight as well, being a public company. Then public companies also have higher costs and more stringent compliance and stricter reporting and audit requirements. So, e.g., for private companies, you do not have to have a company secretary, but for public companies, it is mandatory. You would have more directors in a public company, as opposed to a private company. So the best fit is that this structure would not be suitable if you are just acquiring a single residential plot. It is designed for high-value investments, commercial investments, where now the overheads of compliance will be justified. The final solution would be now to incorporate a limited liability partnership under the LLP Act 2011. This again has not been mentioned under the Land Control Act, which only restricts private companies and cooperative societies. The LLP is a separate body. It provides limited liability protection to foreign partners. However, if it is deemed foreign-owned, if majority of the partners are non-citizens, it will be deemed a foreign LLP and thus fall under the 99-year-old tenure restriction. So you cannot really hold freehold land if your majority partners in an LLP as a foreigner or as foreigners. And then we also need to be aware that law is not static. There are many changes that happen every other day. There are many legislative proposals that come up every other day as well, which could now seal these loopholes we are seeing. Then another issue is on compliance by LLPs. They are subject to mandatory filings, including the beneficial ownership register, and requires a lot of transparency. So let me go back. Regarding ultimate foreign investors. So on our next slide, we have put this information in a table, setting out the level of risk and the access to agricultural land vis-a-vis the solutions, and seeing the security to the foreign investor. And we've also put another column where we think which solution fits best for what sort of situation that may arise. So you need to be aware that all these 4 solutions, there is none that is a one-size-fits-all answer. The best legal path would depend on your risk tolerance, your risk appetite, your investment scale, and your timelines. So when you're ready to undertake some investment of this nature, it is always best to seek legal advice, and we will be at hand to provide to you the best route to take and which of these solutions would best suit your circumstances, of course, after having conducted the DD. There is one thing I said I would address after that. That was something about the ELC. Allow me to go back to the slides. Yes, I believe it was this slide. It was still under the due diligence. Another area would be an enforcement of a charge, and where now a party would default from the repayment set out in that charge. The banks or the financier would then have the statutory power of sale kick in after, of course, issuing the necessary notices, and they proceed to seek a sale of that property. So any disputes arising from that, I think, which has been some confusion, fall under the High Court and not the Environment Land Court. So when we are also doing the due diligence for the property, we will also check to see whether this property is the subject of some litigation ongoing, and we'll be able to advise accordingly. So if a foreign investor has been financed and is holding certain land and they default, then the appropriate remedy is through the High Court and not the ELC. I think that is the point I had left behind. I think that is it for me. Apart from now, I would need to issue a disclaimer to our attendees here. Our presentation today is just for informational and educational purposes. It is not legal advice. So please do not go out there and say that Sylvia confirmed that this is what should happen. For any transaction you are undertaking, specifically for land, acquisition of land, anywhere in Kenya, not only at the coast, kindly seek some legal advice and engage a surveyor as well to conduct a proper due diligence. And then, as I already said, Kenyan law is subject to change, and the information which we have provided here may not reflect any latest legislative or judicial developments. Thank you so much for your time, for listening to my colleague Lydia and I. I think we are now ready to take in any questions that you may have. Lydia, I think I'll begin with you. I had seen some 2 questions touching on conversion from freehold to leasehold titles, whether it is free of charge for non-citizens, and there was also a clarification being sought. I think Jacinta asked that question. Can you see the Q&A box, Lydia?
Yes, I can.
Yes, the second question was on who is procuring the land control board consent for transmission of restricted agricultural land. Maybe you can take us through those 2 questions and then we can answer the others as they come in.
Okay.
Thank you.
Thank you, Sylvia. So for the first question from Jen Kago, in practice, is the process of conversion from freehold to leasehold fees free for non-citizens? When I was doing my presentation in regards to the conversion, then it is clearly stated in the regulations, that is the Land Regulations 2017, that the process will be the foreigners, or rather the non-citizen who seeks to convert their land, will not incur any additional fees. So to answer your question in simple terms, yes, it is free for non-citizens, and that is, you can back it up with that provision in the land regulation, and the body that will bear the processing fees is the National Land Commission. So the non-citizen doesn't need to worry. The fees will be borne by the National Land Commission. And then and essentially it is for non-citizen, because for a citizen, of course, you will not want to convert your land to a 99-year-old lease. Why? Basically it's for non-citizens so that they comply with the legal framework. Yeah, I hope that answers your question. Question 2 from Jacinta Charago. Please clarify who is procuring the Land Control Board consent for transmission of restricted agricultural land. So, Jacinta, the first thing I said about getting the land or procuring the Land Control Board consent from the Land Control Board is that transmissions are exempted, but it only happens when that transmission is going to have the land subdivided into 2 or more portions. So when such a scenario occurs, then normally it is the transferor, or rather whoever is transferring. So for example, if I am the executor of the estate, for example, and I'm transferring that I'm having it, I'm applying, I'm the one who is who wants to subdivide the land, because in a succession process, what happens is the land, the property first goes to, specifically land now, which we are talking about land, first goes to the executor of the estate. And then from the executor, now it will go to the beneficiary. So assume the process of succession is finalized, and then it has come to the executor. So it means it is this executor or the personal representative, depending on whether the deceased died leaving behind a will or not. So assume that we are dealing with an executor. This executor is the one who will apply for that Land Control Board consent in their capacity as the executor of the estate. So depending on a scenario, whether it is the executor, the personal representative, or even if the executor, you realize that in most cases, or in some cases, the executor is the same as the beneficiary, or rather the personal representative is the same as the beneficiary. So you will just write, if it is Lydia, or rather if it is Jen, it will come from you, Jen, as the executor, to you, Jen, as the beneficiary. So when you're applying for the Land Control Board consent, it means you, as Jen, you will apply for that consent as the executor of the estate, and then you're seeking for that consent to subdivide the land, to transfer to who? You, again, as the beneficiary. So I hope your question is answered in regards to who procures the consent. And then I've seen the third question from Ken, from Kennedy. He says, at times when you do a search, you'll find the lease term reading 9 years. How do you explain that? So Ken, to answer your question, that's just a tenure like any other. Just the same way you can get a title with a lease of 99 years. You can get a title with a lease of like 50 years. And even you can get a title with a lease of 40 something. So there's nothing so unique about it, only that it is the tenure. It's 9 years. So depending on the lessor or whoever granted the lease, they decide, I want to give you a lease of this amount of period. So for those titles that you see, because they are there, majority, there are so many, just take them like any other title. There's nothing so special about them, just the tenure, like the way you can just grant a leasehold interest of whichever way, depending on the agreement between the parties, or rather what the lessor wishes to grant. So, and then when I go back to what I talked about in regards to the conversion, I had said that for foreigners, that the land regulations part 3 talks about conversion of first the freehold for a foreigner holding a freehold property, and number 2 for foreigner holding a 99,999 or rather a leasehold exceeding 99 years, which now brings us to your question. So even those ones have to be converted so that they don't exceed the 99-year-old threshold that has been put by the has been limited by the Constitution. I hope I've answered all the questions. Yeah, thank you, Sylvia.
Thank you, Lydia. Kennedy, maybe if I may add on to what Lydia has said, where this 999 years came from, we were colonized by the British. When they were issuing titles which they had taken from the locals, they wanted to grant themselves freehold leases, essentially, but they were thinking that if we give 999 years, there is no way that this land will revert to the locals we took it from. So that is where it began. If you notice, if you see a copy of those titles, you'll see it was issued a very long time ago. It was just essentially the colonial masters at the time wanting to bequeath freehold titles to themselves and to their descendants. There is one more question from an anonymous attendee who is asking if the training materials will be shared with the participants after the webinar. Yes, we are happy to share our slides with you. But then again, take note of our disclaimer that our presentation is not legal advice and should not be taken as legal advice. So if it's just for information and education. If you need some legal advice, we are at hand to assist you. We shall be sharing our contacts in the chat box. Feel free to contact any of us, myself and my colleague Lydia, and we will be able to attend to any of the questions you may have for us. Our contacts are now on the chat box. You could pick them up there. We will be happy to hear from you. Also, on any feedback you may have for us or on any other topic that you may be interested in. There is another question here from Anthony. Hi, Tony, how are you? Can a foreigner use an investment trust to acquire property in Kenya apart from the LLP JV public company? Just from the top of my head, I would look at it in this way. What restrictions apply? What vehicles are restricted under the Land Control Act? So, and excuse me, sorry, what oversight does, if at all, are there any oversight bodies overseeing the vehicle I'm proposing to use in order to circumvent those restrictions and acquire that land? So I would see no issue provided I have answered all those questions. All right. There is also a comment here from Anna. Oh, there is a title that has 9,999 years as the term. So you would see the kind of mischief that arose, as opposed to just indicating that the title is freehold. And then, sorry, to go back to Anthony's question, I have just confirmed that holding in trust is restricted under the Land Control Act. Therefore, you cannot acquire the property through an investment trust. So for us, I think those four vehicles are the ones that are applicable as at now, of course, subject to any development in the law. That is it from us today. Thank you so much for joining us. We look forward to hosting you again very soon on one of these topics that are mind-boggling, especially at the coast, especially for foreigners. Thank you very much. Have a good afternoon. For those in the diaspora, have a good day, because it's very early morning for you. Thank you.